हेलो हेलो मिस्टर सतीजा।
या डॉक्टर साहब, हाउ यू?
आई एम फाइन सर, हाउ आर यू?
बस बस बढ़िया, आप सुनाइए। कैसी चल रही है आपकी छुट्टियां, कैसी चल रही है?
सर पागल हो गए, बोर हो गए, बोर
बोर हो गए? आपने भी दाढ़ी बढ़ा ली, देखो मैंने भी दाढ़ी बढ़ा ली।
हाँ पागल हो गए, आई हैव गॉन मैड।
चलो मेरे ख्याल से बाकी लोग भी शायद देख रहे हैं। ओके चलो देखते हैं। ओके ओके ओके। That's fine. तीन चार हुए देख, अरुण सतीजा, चंद्रशेखर अभी तो चंद्रशेखर से बात भी होगी, मेरा जानता है। तो मिला नहीं, मेरे चैम्बर आया था तो वो तो 30 ही गया था, दाढ़ी वाला कह रहा था कि बड़ा अच्छा है, मैं लेक्चरर हूँ, मैं मीटिंग में लेक्चर देता हूँ, मैंने वाला वो बैठा था सामने। इसका लेक्चर है ये बैठा रहे, इनका लेक्चर है क्या?
इस टाइम शक्लें ऐसी हो रही हैं, पहचाने ही नहीं जाएंगे।
बिल्कुल बिल्कुल बिल्कुल।
He is your son?
या जिनसे आप मुलाकात हुई थी।
हाँ हाँ, ऊपर गोल कैंटीन में ऊपर।
बिल्कुल बिल्कुल बिल्कुल। इससे भी उन्होंने बाल शेव कर लिए, इसने भी।
अच्छा अच्छा, हाँ तभी पहचानने में नहीं आ रहे।
हाँ हाँ हाँ।
बढ़िया।
हेलो
हेलो।
देखा पहचान लिया इसने, गोल कैंटीन में मिला।
नहीं है यो पॉइंट को एक जो पागल गला पड़े रहे, एक जो पागल गला पड़े तुम्हारा आपको अभी
ओके, तो आज एक और लाइव, बहुत ही शानदार आज का दिन बीता। कुछ बहुत अच्छी अच्छी चीजें नहीं हुई, पर आप लोग का भी ये जो जिंदगी चल रही है इसमें धीरे धीरे कुछ लोग मेहनत करने लगे होंगे, कुछ लोग करने शुरू होंगे।
रविंद्र क्यों, मैंने बोला तो है कर रहा हूँ। कहाँ पे है अभी? ये मैं 10 मिनट में करता हूँ।
आ रहा है नाम, आ गया।
Madhav, are you online? Madhav, can you hear me?
Yes, I can.
Madhav,
I can.
Madhav, can you hear me?
Yes, I can. I can hear you, sir.
Madhav,
Sir, I can hear you. I hope I am audible.
Madhav, can you hear me?
Yes, sir. I hope I am audible.
Madhav, you are not audible to me.
Sir, I'll then just a minute then.
बाहर ना जाए वोडाफोन या आइडिया के नंबर का रिचार्ज या बिल का भुगतान माय वोडाफोन ऐप या माय आइडिया ऐप से करें कोरोना संक्रमण से बचने के लिए
Yeah, Madhav, you are audible now. Yes.
Am I audible?
Yeah.
Sorry.
Yes, sir. 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 Sir, it is increasing. ठीक है सर. हाँ. ठीक. सर हो गया और सर आ रहा है अभी मैं करता हूँ और ऐड कर रहा हूँ सर. ठीक.
Nitish sir, am I audible?
Yes, you are audible. You are audible, Madhav.
Thank you.
Let Robbie sir bring Justice Ansari, then I'll hand over it to you.
Okay, sir. The moment Ansari sir's image comes on the screen,
Yes.
I'll start speaking.
Yes.
Thank you.
Good evening, everyone. We'll soon going to have our today's keynote speaker, Justice Iqbal Ansari, ex-Chief Justice of Patna High Court, in 2 minutes from now. Thank you, all of you. Madhav, can you hear me?
Yes, sir. Yes, sir. I can.
Madhav, can you hear me?
Yes, sir. You're audible.
Sir is here in between us. Sir, good evening on behalf of all of us. Madhav, from here onwards, please take it. Madhav.
A very good evening, everyone. I'm Madhav Sareen. This is my tremendous honor to introduce our learned speaker today between all.
Yes, Madhav is here. Madhav, can you hear me?
Yes,
You are not
I can.
audible to us.
Hello, hello, hello. Am I audible?
Yes,
Now am I audible?
visible to everybody. Yeah.
I am audible. I hope I am
Madhav,
audible, sir.
can you hear us?
Yes, yes, yes. I hope I am audible.
Madhav, can you hear us?
Yes, sir. Yes, sir. Yes, sir. Yes, sir. A very good evening, everyone. I'm Madhav Sareen. This is my tremendous honor to introduce the learned audience with our keynote speaker today, Honorable Justice Iqbal Ahmed Ansari ji. And I would like to thank Robbie sir and Geeta Luthra ma'am for giving me this opportunity. We are indeed privileged that we have been blessed by the delight of Justice Ansari's presence. Justice Ansari is one of the greatest legal luminaries our country has ever had. And sir has also served as the former Chief Justice of Patna High Court and is currently the chairperson of Punjab State Human Rights Commission. Today, we are filled with both merriment and curiosity as sir, who has delivered some landmark judgments, is going to educate us on the topic laws of plea bargaining in India in comparison to the UK and the USA. And sir, now we would love to hear it from you.
Thank you, Mr. Sareen. Distinguished invitees, ladies and gentlemen, can you all hear me? Am I audible?
Yes, sir. Yes, sir. Yes, sir. Audible.
Can you hear me?
Yes, sir.
Mr. Sareen, can you hear me?
Yes, sir. Everyone can hear you, sir.
Yes. Okay. While I appear to speak on the policy of plea bargaining in India and its comparison with the United Kingdom and United States of America, I am reminded of a book written by Felix Green somewhere in 1960s when we were students. The book goes by the title, The Wall Has Two Sides. The book is actually on the happenings of China, because China those days was known as iron country, meaning thereby that nothing from China was known to the other parts of the world. So it was looked down upon, but at the same time, the book mentions those cases where the China had made tremendous achievements, including the concept of open jail. I don't know how many of you know that China had, and I don't know whether they still have or not, a system of open jail where the prisoners were not kept under guard. But if they left the jail, their friends and relatives used to bring those prisoners to the jail and hand it over to the authority concerned. Plea bargaining, to my mind, offers to us a wall which has two sides. It has the merit in the plea bargaining. There are serious demerits in the policy of plea bargaining. And India has started this entire policy with definite limitations, because there are two judgments of the Supreme Court delivered by very celebrated judges of the Supreme Court, including a Chief Justice of India, Justice P.N. Bhagwati and Justice Krishna Iyer. They said that as far as the Indian Constitution is concerned, it does not recognize a concept of plea bargaining. Please bear in mind. So we had this limitation, we still have this limitation, because nobody has taken away these words. Of course, these two judgments were delivered in the cases of minimum punishment prescribed for imprisonment. If you will recall, under the Prevention of Food Adulteration Act, before the Food Safety Act was introduced, there was the minimum sentence of imprisonment was of 6 months. So dealing with this case, the court said that no, the question of plea bargaining, and there the court also noted that we are aware of the fact that such a policy is in vogue in US and UK, but Indian jurisprudence does not recognize it. So this was the limitation. Now, when we hear the judges of the High Courts or the Supreme Court exhorting the judicial officer to be proactive in matters of plea bargaining, the question arises, can there be a role of a judge which we can call as proactive? Could the authorities of Delhi High Court held a local adalat of plea bargaining in Tihar jail? It was held long time back, but nonetheless it was held. There you will find that because of these limitations of the Supreme Court, when the recommendations were made by the Law Commission of India, they had given two procedures for application. One was that the accused will apply, seeking the benefit of the policy of plea bargaining. Another recommendation of the Law Commission was that even the court can act suo moto and resort to the policy of plea bargaining and inform the accused accordingly. This was done away with by the parliamentarians, that is, while enacting the provisions with regard to that in the Code of Criminal Procedure, meaning thereby that as far as the courts are concerned, they do not have suo moto power of resorting to plea bargaining. Then where is the question of taking proactive role? And this is coming more from the National Legal Services Authority and the State Legal Service Authority. The judges demand that the lawyers and the judicial officers shall take the benefit of the plea bargaining. So far as the accused is concerned, the role of the judicial officer is to inform the accused that such a provision exists, and the role of the court ends there. Thereafter, it is entirely for the accused to plead guilty or not plead guilty or apply for taking the benefit of plea bargaining. As a matter of fact, you will find that under the CRPC, the provisions have been made for making an application to the court by the accused seeking the benefit of the plea bargaining. And there you will find that the court is required to determine if the application has been made voluntarily. Now, once we determine voluntarily means the test will be same as in the case of a confessional statement of the accused. When an accused wishes to make a judicial confession, the magistrate determines voluntariness of the confessional statement. With the same strictness, the court has to determine as whether the accused is making the application voluntarily. And at this stage, that means whether it is free from any kind of inducement, threat, promise, undue influence, etc. Now, as against this, I don't know how many of you are aware of the fact that when you travel over to US or UK, you will find that the charges which are framed by the courts in India, these charges are framed by the prosecution. And the plea bargaining process can be initiated by the court, by the prosecution, or even by the victim. There is no role of any of these persons as far as India is concerned. In fact, I have seen in at least one case in UK where the judge was almost threatening the accused, saying that this is the benefit available to you today. It may not be available to you tomorrow. Little realizing that it was entirely the option of the accused. And that is why there is a concept of drop trial. I don't know whether anyone of you have heard of drop trials. Because before the trial is started, there is a system of hearing on the calendar of the trial. A witness will take 10 minutes, B witness will take 20 minutes, C witness will take 30 minutes, whatever it is. So a complete calendar is prepared of the entire trial, and the courts, as well as the prosecution and defense, try to adhere to that timing. Now assuming if one of the accused or in one case, the accused opts for plea bargaining, then the entire trial is over. So there it is known as a drop trial, and that trial, the remaining part of that calendar will be filled up by another trial, which will be kept ready by the prosecution. Now the Crown Prosecution Service in England, for instance, prepares the charges. Now when we don't have any system of plea bargaining on charges, but because of the wrong training perhaps that we have given, we have come across such cases where even cases of 102, 302, that means murder, has been compromised by the judge or the judicial officer, thinking that he is empowered to do is he has no business on the charges. He can't reduce the charge from 302 to 304 or 304A. But this is possible in the Western world, particularly of the common law countries I'm talking about. I have seen a case where there was a maid, very old, very, very old. The employer gave a check for a certain amount of money. She added one more zero and presented it to the bank and encashed the check. Subsequently, when she was caught, obviously she was to be prosecuted for forgery, fraud, etc., etc. But in order to save her, because she was too old, the Crown Prosecution Service framed the charge of theft. Can you believe it? In India, we cannot do it, and we don't do it. But there it is possible. Almost it is a fraud on the judicial justice delivery system that a person who has committed a forgery by adding a zero in the check is allowed to go. Hello? Hello?
Sir, you are audible. Audible, sir.
Acha. So coming back to the subject that I had been discussing with. So these are major differences between the US and UK on the one hand, in India on the other. In India, there is, as I said, because of the two judgments of the Supreme Court, there was a reluctance, and this reluctance is discernible from the recommendations of the Law Commission of India and the subsequent enactment by the Parliament. Coming back to the subject that I have been discussing with, these are major differences between the US and UK on the one hand, in India on the other. In India, there is, as I said, because of the two judgments of the Supreme Court, there was a reluctance, and this reluctance is discernible from the recommendations of the Law Commission of India and the subsequent enactment by the Parliament. Second time बोल रहा है. Second time it is speaking. Recorded one also.
It is spoken, not audible correctly. Is somebody else speaking now in there?
I also thought. No.
From the recommendations of the Law Commission of India, subsequent enactment by the
Parliament. Coming to our subject of plea bargaining, what is that at the time when the plea bargaining is there, you will find the provision under the CRC speaks of holding a proceeding in camera, and this will be between the accused and the magistrate. Nobody else will be present. What does this mean? It means that the court has to determine whether the application for plea bargaining has been made under any influence of the accused, the victim, of the victim or the prosecutor. And that's why there is an application provided for making for the plea bargaining by the accused. The provisions are also there that the court will issue notice to the public prosecutor, the complainant for the advocate for the accused, or the complainant of the accused, or the complainant if required, and then determine. There also is a provision, as I have said, of holding a proceeding in camera. In camera means when the accused will be without any influence of the prosecutor or the victim. And in such a way, in such a situation, where is the scope of the judge being proactive? That means though it helps in the disposal of the cases and increasing the number of cases of disposal, but that is not allowed by our CRPC. That is what I am trying to point out. It's a good idea. That means at least the small cases, the accused will pray and take the benefit of the policy of plea bargaining. It will help in the reduction of in the maximization of the disposal of cases. But at the same time, this will be against the policy of the law, because the law does not perceive of such a situation. And that is what the judicial pronouncement have indicated. Now, when the application comes for seeking the policy of plea bargaining, the court has the option of providing for a compensation, and if there is a question of compensation, then a notice is required to be compulsorily given to the victim, and the CRPC uses the mutually disposable. So it has to be mutually disposition. That means the agreement which is read is to the satisfaction of the prosecution, the defense, and also the victim. But when there is a question of compensation arises, that compensation has to be where there the accused, the victim has a specific presence. Because complainant does not necessarily mean victim, but victim means a victim. And that's why in CRPC you will find in the case of compensation, when the question of compensation arises, the CRPC uses the expression victim. I may also mention that as far as India is concerned, India in the court martials that we have, the system of prosecution framing charges there. In court martials also, it is not the court which frames charge. That one must take note of. This was the practice during the English era. Same practice has been continued even after we have become independent. Hello. Hello.
So you are audible.
No, because we will have to give time for questions also. That's why I was wondering.
So you are audible, sir. Audible, sir.
But I don't know whether there will be some questions. If the questions are required to be asked, because it is already 5 minutes past 6:30.
Sir, no problem, sir. Sir, you can continue, sir. Continue.
Okay. So if there is any question to be asked, you can ask me.
Definitely, sir. Definitely.
Okay. So the major shift that I had been talking about on the matter of policy, this came up in the National Judicial Academy at Bhopal, when we came to learn that about 500 odd cases have been disposed of by Delhi High Court in Tihar jail what do you call it? Lok Adalat. And we were very curious to know as to how the Lok Adalat could have been divided. And eventually Delhi High Court said that no, it was perhaps not a very correct procedure. So this is what I wanted to say in all with regard to these differences which are major. And I must also say that even in the present case, our lawmakers have not allowed plea bargaining in the cases where there is minimum sentence prescribed, because if there is a minimum sentence, then in that event the sentence can be reduced. In the case of other offences, it will be 1/3, but in the case of the minimum sentence where it is prescribed, it will be half of the sentence, which can be imposed by the court, and the court will prepare a report. There is also some debate that this report is meant for whom, because the court does not require this report and the court is not required to submit this report to anyone. And nobody can interfere with the proceedings of the court. But this report, perhaps to my mind, is provided for in order to keep as to what has actually happened in the proceedings of the court, because as such, we don't have a system, unlike the Western countries, of recording everything in the court. And you must remember that in the Western countries where the common law practice is in force, the entire proceeding is recorded. There was this system was in vogue even at that particular time when we did not have this CRPC. It was only with the present CRPC that it has been dispensed with. Otherwise, every word, whatever everyone speaks, would be mentioned in the proceedings of the court. So, I've made a mistake. It is not 1/3, but is 1/4 of the punishment prescribed. To that extent, so it is beneficial. If properly explained, the accused will resort to it. But the court cannot persuade the accused to resort to the policy of plea bargaining, nor can the prosecution do it. Whereas in England or in America, it can be done by the prosecution, it can be done by the court. If there is any specific question, I will take it because we do not have sufficient time available with us.
So if any of the viewers have the question, Justice Iqbal Ahmed Ansari is kind enough to answer that. I am once again repeating that any audience, if have any question, Justice Iqbal Ahmed Ansari is ready to answer those.
Hello. Hello.
Yes.
Good evening, sir. Sir, I am Ravi
Good
Mehta.
evening.
Sir,
yes.
Sir, can we revoke the proceeding after making the statement before the court, just before the pronouncement of the verdict of the judge?
Once we understand it clearly that it is on the voluntariness of an accused that this entire scheme is dependent, there is no reason why he cannot be allowed to retract from his application of plea bargaining. Because in fact, such a possibility remains. Once he applies, the court determines as to whether it is voluntary or not. Second time, after giving a notice, the court gives him a hearing in camera. There again, the court tries to find out, is it voluntary or not? So there is no reason to think that once he applies and it comes up for hearing, thereafter there will be no occasion available to the accused to withdraw the plea of bargaining.
Thank you, sir.
So I'm Madhav Sareen. I had a question.
Yes, please.
So I'm a novice in law, so I had a question with the very basic of it. So my question was that if a person plea bargains in the court, will we treat him as a conviction or an acquittal?
Once he is required to undergo sentence, in the case of compulsory compulsory sentence, say for instance half the sentence, and in the case of others 1/4 of the sentence, then in that event the sentence cannot be without a conviction, though there is no proper word of conviction, but sentence will follow conviction.
Okay, sir. Thank you, sir.
So that means in all probabilities, when a person opts for a plea bargaining,
Yes.
the conviction would be necessitated out of it. It is a thumb rule which will follow the plea bargaining.
Obviously, because sentence has same as in the case of civil law, the decree has to follow the judgment. The sentence has to follow the conviction. Until and unless there is conviction, there is no question of sentencing the man.
Sir, I think by this you have made the topic clear to all of us, and we had a little knowledge on the same, but you have thrown the light of the day on the subject. And with this, sir, we also take the permission of yours, sir, and we are so much thankful and obliged to you on behalf of the entire team of lecture series on law. Thank you so much, sir.
I had no idea that 1 hour will be giving me so much of time. Otherwise, I would have perhaps started with many things which I have not spoken. There is still things to be learned in this particular subject, but because I found this subject very fascinating.
Sir, we would also like to you as a speaker on our board, sir, soon with some another and interesting topic, sir. Thank you so much, sir, for your time, valuable time, sir, on the subject.
All the best, and thank you very, very much for giving me an opportunity and honoring me with this privilege. Thank you.
Thank you so much, sir.